The internment of Japanese Americans during World War II was not only the fault of President Franklin Roosevelt, but also a complicit Supreme Court that should have, but didn't, protect the civil liberties of these Americans. While this is the most known and notable example of the Supreme Court allowing American civil liberties to be violated during this time, it's not the only example, and the precedents they set during that time period continues to deprive Americans of their civil liberties today. I'm Ben Murray, director of the Fiscal Policy Center here at Independence Institute, and I'm back on this week for our final installment with Rob Natelson for his Supreme Court series, How the Supreme Court Rewrote the Constitution. Rob is our senior fellow in constitutional jurisprudence at Independence Institute and also runs our Constitutional Studies Center. Rob, thanks for coming back on.
Good to be with you.
So, Rob, last week we talked a lot about how the Supreme Court rewrote the Constitution in a way to let the federal government intervene in the economy. This week, we're going to talk about civil liberties. And I want to dive right into that. To start that section, you talk about a case, a Caroline Products case.
Yes.
And if I understand correctly, what this really does is it kind of creates this what the case did was create this hierarchy of rights, if you will, in the Constitution. I mean, am I understanding that right? Is that the way the founders envisioned that there would be this kind of hierarchy of rights, that this right is more important than that right? Mm-hmm. Explain this to me.
Well, Caroline Products included a footnote, which lawyers call footnote 4. It's famous. And in the course of deciding the case, which was, you have this footnote that's really not germane to the case, in which Chief Justice Stone writes, it's unnecessary for us to consider now whether we should treat some rights more importantly than others. Well, this, of course, was a signal that this was exactly what the court was going to do, that they were going to start treating rights differently. Did the Constitution provide for that? Yes and no. In the Constitution, there are some rights that are explicitly subject to balancing. For example, the Fourth Amendment prohibits unreasonable searches and seizures. That necessarily requires a court to balance to determine whether a search or seizure is reasonable. Similarly, habeas corpus may be suspended only when the public safety requires it due to insurrection or invasion. That requires a court to balance and say, was it really required to suspend the writ of habeas corpus? However, most of the rights in the Constitution do not have that kind of balancing language. And so a traditional court would say, in a free speech case, is this pronouncement protected under free speech as the founders understood free speech? Instead, what Caroline Products did is it announced the beginning of an era in which courts would play favorites among rights. They would demote some rights, like the right to contract in Article 1, Section 10, and they would promote other rights, such as their version of the First Amendment. They wound up ultimately, this New Deal court did, downgrading all rights.
I think it's terrific how you laid this out in your essay series, because that sort of sets the stage for the court sort of giving themselves permission to then undermine other civil rights that are supposed to be guaranteed by the Constitution. And we go right down the line. You begin with the Second Amendment in United States v. Miller in 1939. And you named 3 purposes for the Second Amendment as understood by the founders. What were those 3 purposes, and how did this case limit that or narrow that or change that?
Okay. First, we needn't have any sympathy for Mr. Miller. He was a thug, okay, who had an unlicensed machine gun. However, what we're looking at now is the precedent that the court set. The 3 goals behind the Second Amendment were as follows. Number 1, there had to be an armed citizenry that could be part of the militia to defend the country when necessary. The militia might be under state control and protect against invasion, or it might be nationalized by the federal government temporarily to resist invasion. So that's one purpose, to protect the country. The second purpose was to protect both individuals and the states from domestic tyrants. Remember that the people who wrote this amendment had just been through a revolution against tyrants. And so they recognized that an armed citizenry is one of the great protections against tyrants, as Ukraine is now learning, right?
That's right.
And then finally, they recognized that that citizens needed arms for self-defense, not just against domestic tyrants or foreign tyrants, but against petty criminals. So those were the three purposes behind the Second Amendment.
And the case then, you say, limited the court's understanding of those three purposes to just one. Which of those is it?
The first one, the one that's the court in essence said, well, the purpose of the right to keep and bear arms is just so that we can have a militia to protect against invasion and be available when the federal government wants it. And this guy doesn't need a machine gun for that purpose, and therefore it's not protected by the Second Amendment. This case created enormous confusion for decades thereafter. And it wasn't until 2008 that the U.S. Supreme Court finally cleared away some of the confusion and said, actually, there was more than just one purpose for the Second Amendment. But this was a good example of constricting a right, and for many years, people argued for denying people the right to keep and bear arms based on the Miller case.
Right, and the 2008 case you're talking about is that the Heller case?
Heller case, that's right.
And there's a lot of controversy around that case and around the Second Amendment. But the next thing you talk about is something that there's really not a lot of controversy around today. I mean, most of us agree that we should protect the right of the writ of habeas corpus and trial by jury. But yet, you go into this 1942 case in which the previous, that footnote 4, opened the door to the Supreme Court undermining, and the Roosevelt administration undermining, these essential rights that we really all agree on.
This is ExParty quirin. And again, it's very hard to feel too much sympathy for the defendants. What happened was that Nazi Germany in 1942 sent a submarine with 8 young men in it. And those 8 young men were designed to be saboteurs. They were dropped off on the eastern seaboard, I believe on Long Island, and basically told to fan out through the country to find out ways that they could destroy things. All of these young men had spent a substantial amount of time in the United States, and their English was excellent. So they could pass as Americans. 2 of those young men were, in fact, American citizens. Well, one of them, in the first place, some of them accepted this job only because they wanted to get out of Nazi Germany, right? And one of them, anyway, got cold feet. So he went to the FBI, and he told the FBI about this mission. And so based upon the information he was given, that he gave the FBI was able to round up all 8. Well, Franklin Roosevelt was furious. He lost it. He wanted to take these guys and put them before a military commission forthwith and have them executed forthwith. Now, as a matter of law, if a saboteur comes into your country and he's not an American citizen, as 6 of these young men were not American citizens, that's a permissible way of proceeding. Military tribunal is all they're entitled to. They've been violating the law of war. On the other hand, the 2 Americans are entitled to habeas corpus, and they're entitled to trial on treason charges, right?
Right.
Well, Roosevelt told his attorney general, I'm not going to hand over these people to any U.S. marshal armed with a writ of habeas corpus. And the entire proceeding was kept secret. All of them were tried by military tribunals, despite the fact that some of them had good defenses, or at least colorable defenses. They all were sentenced to death. And again, despite the fact that 2 of them had been promised pardons for turning state evidence, they were all sentenced to death. And finally, Roosevelt agreed to commute the sentences of 2 of them based on their cooperation to long prison terms. So they still had to serve long prison terms. Then 6 of them were quickly executed. The U.S. Supreme Court decides ex parte quirin as if the case is before us, and it writes as if the case is before us, but in fact the young men had been executed before. The court approved the execution, said we're not going to issue an opinion today, Took them 3 more months to issue an opinion, and then this mendacious opinion comes down as if these young men were still alive, right? With no reference to the fact that that 2, not just 1, was an American citizen, and no explanation of why they were not entitled, those American citizens were not entitled to a writ of habeas corpus and indictment by a grand jury and trial before a trial jury.
There's so many things I could say about this. Can you imagine what the ACLU would be saying right now?
Oh, right. Well, the ACLU is a highly selective in its outrage. I've always thought and this is not just recent, I've always thought its outrage has been selectively vented to propel the jet engine of the left.
And my other thought is, wouldn't it have been awkward if the Supreme Court had ruled against the Roosevelt administration, and then all the administration would have to say is, "Oops, well, we already killed him."
Yeah, right. Well, what the Supreme Court should have done when the young men had good legal counsel representing them. I think, in fact, the government wasn't really expecting how vigorous and competent the legal counsel was. But they went to the Supreme Court and they say, we want a stay of these executions. The Supreme Court refused to stay the execution. What the Supreme Court should have done, of course, was stay the execution and then consider the case and take the time necessary. These folks didn't have to be executed in 2 weeks. They could have been executed if found guilty, and their convictions were confirmed in 2-3 months. So when people tell you what a great president Franklin Roosevelt was, and in some ways as a war leader he was a great president, but there were severe flaws on the record, and those flaws are not widely understood.
Well, and this is where we're going to get to the internment camps, which you talk about as well. But I want you to start connecting dots a little bit for folks here who've watched our previous videos and also from what we said earlier. How is it that footnote 4 and the makeup of the Supreme Court that we talked about in previous videos enabled this outcome in this case?
Well, what happened was that Roosevelt replaced seasoned justices as they retired or died with people who I think he perceived as hacks. Some turned out not to be hacks eventually, but early on, after they were appointed, they basically, to use your term, rubber stamped whatever Roosevelt wanted. They were people, by and large, who had political debts to the president.
Mm-hmm. And what about that footnote 4? How did that play into this case?
Footnote 4 signaled to the court that it was going to start balancing constitutional rights according to which rights it thought was important or not. And it de facto did that in the quirin case, and it did it overtly in the next case, Korematsu versus United States.
And that's the one that I really want to get to. We're going to wrap up on this one, but this is an important one. This is the infamous internment camp case. I'll just let you dive into it. Tell me about this one.
Sure. There had been an earlier case called Hirabayashi versus United States involving a young American citizen named Gordon Hirabayashi of unquestioned loyalty, who was convicted in a very disingenuous opinion by the U.S. Supreme Court of disobeying a removal order and disobeying a curfew. Now, here was the situation in the western states. The military command had issued 3 orders, and these orders were applicable only to people of Japanese descent, whether American citizens or not. One order was to report to a local center and be sent to a concentration camp. The second order was to stay where you were, not move out of your house. And the third order was to get out of the area.
These sound contradictory.
They are. They're absolutely contradictory. And so what Gordon Hirabayashi did is he stayed in his house, but he did not report to a center for being sent to concentration camps. The Supreme Court, through Justice Stone, wrote an opinion upholding his conviction for failing to abide by the curfew, never mentioned the conviction or didn't deal with the conviction for not reporting to the Center for Deportation to a concentration camp, and therefore did not overturn that. Both convictions were essentially confirmed. And it was 40 years before Hirabayashi was finally vindicated, and those convictions were set aside in 1987.
Wow.
The other one, the Korematsu case, involved Fred Korematsu. He was also an American citizen. He was a native-born American citizen. again, unquestioned loyalty. And he likewise was convicted of violating these contradictory orders. And he fought it all the way up to the U.S. Supreme Court. And the big issue before the Supreme Court was, could they intern these American citizens and also Japanese citizens who were here by permission without a fair trial, without any charges whatsoever?
You didn't explicitly say something that should be obvious, but I'm going to ask it. Was the internment of Japanese Americans in World War II constitutional?
Obviously not, because there were no charges preferred against them. There was no right of habeas corpus, no trial by jury. A whole collection of rights was violated. And by the way, it's easy for us to look back at that and say, boy, that was awful. We would never do that again. Remember, however, that there was a lot of panic at that time about the possibility of a Japanese landing on the West Coast. There had been an incident on the Hawaiian island of Niihau in which 3 Japanese Americans had kind of turned against the country, which scared people. So there was a certain amount of panic. But the measure of a judicial system is its ability to surmount that panic and enforce the Constitution and the rules even when it's inconvenient to do so. It's also easy for us to say that, oh, gee, that kind of thing could never happen again. That kind of disregard for civil liberties could never happen again. Well, it turns out that what was a day before yesterday, a federal judge has just enjoined the Biden administration against a massive course of violation of free speech rights and free press rights in its manipulation of social media in order to quash messages with which it disagreed. So this is something that every generation has to deal with. And what's important is that we learn from future generations and be prepared for this when it comes so that we can respond appropriately.
Well, what I'm concerned about, Rob, and you may have answered my question, but so the gentleman, I forget his name.
Korematsu. Yeah.
Was his decision was reversed in 1987. But when the court passes down a decision like this, it's precedent.
Yes.
Is this still precedent? I mean, could this happen again?
Well, yes and no. The type of balancing that Justice Black introduced in this case, again based upon footnote 4, is called strict scrutiny. Strict scrutiny is a formula by which rights are, it looks like a formula that protects rights, but it's actually a formula by which the government can override rights. So if the government demonstrates to the court that its suppression is necessary to what the court and the government think is a compelling governmental interest, then the right can be suppressed. The judgment of what a compelling governmental interest is entirely subjective. For example, there are courts now that say that discrimination against people for homosexual activity, preventing that is a compelling governmental interest, when only 20 years ago that kind of activity was illegal in many states. So it shifts with the political fashion as to what is or isn't a compelling governmental interest. So that part of Korematsu survives. The specific holding, the specific conviction of Fred Korematsu obviously has been overturned. Fortunately, I'll say this, Ben, that there are signs that the current Supreme Court is beginning to move away from the balancing somewhat. Last year in the New York Rifle Association case, an opinion by Justice Thomas explicitly refused to balance away the Second Amendment. And just very recently in the 303 Creative case, 303 Creative versus Elenas, the court refused to balance away Laurie Smith, the owner of 303 Creative, refused to balance away her right to free speech. So there are signs that the court, after 70 years, is finally moving away from this.
You know, what I hear is that a lot of the precedent that was set during the New Deal era, World War II era, still affects us today.
Oh, yeah.
It still impacts the way the court understands the Constitution. And even though in particular cases, some of the most egregious things have been in one way or another overturned, the seed is still there.
Yes, it's more than a seed. It's a very large tree. In fact, this court, even though the media like to call it a conservative court, this court, for the most part, Roe versus Wade is a big exception, continues to apply the liberal jurisprudence that was developed by progressive majorities on the court during the 20th century. Any change there has been, except for Roe versus Wade, has been very incremental, as indicated, but it is indicated by the New York Rifle Association case and 303 Creative versus Elenis. But it's very incremental change.
So the reason for optimism here is that we have a court that sounds like you're saying we don't have a radically conservative court today.
No, we have a mixed court. It's a court that swings back and forth. And I've documented that very convincingly, I think.
So we have a mixed court. This court is not conservative in the way we talked about in our previous interview, in that they were actively
right. There's no one on the court like that.
Conservative. But instead, we actually have a court today, and this is a reason for optimism, that is more willing to actually interpret the Constitution the way the founders intended it to be understood, even despite previous rulings that were an overreach.
Yeah, it's too early to talk about Justice Jackson, but all the 8 members of the court, including the other 2 liberals, are willing to pay courteous attention to originalist arguments. They may not always follow them, but there's only one member of the court who says that originalist arguments, that is to say arguments based upon the traditional method of documentary interpretation, that they're decisive, and that's Justice Thomas. So you have right now, you've got 3 liberal activists on the one side, you have Justice Thomas on the other, and then you've got 5 others who are willing to accept originalist arguments, but they have other priorities too. If the 3 liberals can convince 2 of those 5 to move their way, they got a majority. And they had a lot of majorities in these past terms. Yeah, on the other hand, if Justice Thomas can convince 4 people out of the middle to move his way, as happened with the overturning of Roe versus Wade, then he's got a majority. But that doesn't mean at all, obviously, that it's a conservative Supreme Court.
It sounds like it's far from an activist conservative Supreme Court.
Now, I will say, to get back to the point here and wrap up, is that there were 2 powerful dissents in the Korematsu case. And at the same day that Korematsu was decided in a case called ExParty Endo, the court ordered the release of a Japanese-American woman who had been in a camp for over 2 years without charges. And they did grant her essentially a writ of habeas corpus, and they ordered her release. This was the beginning of the end of that low point for the U.S. Supreme Court. Subsequently, while it never completely cured the damage, it did become less of a rubber stamp for the political branches of the federal government.
If you want to see more of Rob's work, you can go to i2i.org or thinkfreedom.org and click on issues and go down to the Constitutional Studies tab. Run keyword searches like rewrote or Supreme Court SCOTUS, and you'll be able to find all of his work there. I encourage you to go read that. I encourage you to go back and watch this whole series if you haven't. For now, I guess we'll be signing off on this series, and thank you so much, Rob, for walking us through this. It's such an important topic right now at this time when the court's coming out with these a lot of breaking decisions.
And thank you for your work, Ben, here at the Independence Institute.